Yes, sir.
Good morning, Brian Bibb. I'm going to be presenting joint argument on behalf of all appellants in this case. May it please the court, I would like to reserve 3 minutes of my time for rebuttal. As I said before, Brian Bibb of the Knoxville Bar on behalf of the town of Greenback, Tennessee and the Loudoun County Regional Planning Commission. This is an appeal from a disposition of cross motions for summary judgment in a land use case. The issue in this case is whether or not the town of Greenback's zoning ordinance prohibits the operation of a quarry. There's a lot in the record. I'm sure the court has had a chance to go through that. I'm going to try and hit some very high points just to set these legal arguments up. This deals with a property which has been referred to in the record as the Hutton property, a 236-acre tract. In 2023, Mr. Rodney Murphy, the proprietor of M&M Stone Farms and Tri-County Crushed Stone, which I will refer to as the property owners. I think it's worth noting to the court that these were cross suits, so it's difficult to refer to one party as plaintiff or one party as defendant because all parties are postured as plaintiffs and defendants. In performing his due diligence to purchase the property, Mr. Murphy visited the town of Greenback Municipal Building, reviewed the published zoning map of the town of Greenback, which indicated this property was covered by M1 zoning. The official records of Loudoun County, which handles zoning and planning functions for the town of Greenback, also indicated this property was covered by M1 zoning. Mr. Murphy was given a copy of those M1 zoning restrictions and acknowledged publicly his understanding that this property was covered by M1 zoning.
Counsel, the maps, there's a series of maps
Sure.
It's essentially pointing towards. Have those maps been authenticated by the municipal legislative body?
I think that's a complicated question. So let me deal with authenticated. So from an evidentiary standpoint or like a legislative standpoint?
Let's try both.
Okay, so let's start with evidentiary. Yes. So there was a appropriate authenticating affidavit. There in opposing counsel's brief, they questioned based upon the testimony of the town's 30.026 designee whether that authenticating affidavit was adequate. The position, as we've explained in our reply brief, is yes, it was, because it's a business record and a public record of the town, and there was an adequate showing under the applicable rule of evidence that those public records and others which the town relied on had been authenticated. The testimony that they refer to is essentially the town recorder saying, I was not town recorder at the time those maps were adopted. So she has no factual knowledge of that adoption.
How about with regard to TCA 13.7.212A? In that municipality, the municipal legislative body shall authenticate, compile, update, keep, maintain, and make available the zoning ordinance map and all amendments as public record. So we have multiple maps here, but have they been authenticated consistent with 13.7.212?
So my position is yes, and let me explain why. So the zoning map constitutes a compilation. So whenever a zoning ordinance, I'm sure the court has reviewed zoning ordinances before, the zoning ordinances we've relied on in this case have similar language that says the zoning map of the town of Greenback is adopted or amended to reflect the specific zoning change that's being made. So the zoning map constitutes a compilation of the records of the town of Greenback. Was that specific map? So, and I want to be clear here, okay? The maps there are historical maps which we have presented as part of our proof to prove up the absence of the original zoning ordinance. So that's a separate issue. But let me talk about the map, the 2019 map, which is in the record. Let me be specific. It's page 13 of our appendix.
This is the publicly displayed
Correct.
map. Okay.
Technical record, volume 3, page 355. So that particular map, the testimony is it was compiled from the Loudoun County GIS based upon the maintained records of the zoning maps of the zoning ordinances of the town of Greenback. There is also a publicly compiled zoning map that is also publicly available at the Loudoun County Zoning Office. It's in a large pull-out drawer, and the maps are quite large. And those maps also reflect the current zoning of the town of Greenback. So to answer your question more directly, was that map, either the 2019 Greenback zoning map or the current zoning map maintained by Loudoun County Planning, were either of those maps brought before the town of Greenback Board of Mayor and Aldermen? And did the town of Greenback Board of Mayor and Aldermen say, this specific map, we vote that this map is adopted? The answer to that question is no. But our position is, under 13.7.212, those maps constituted a compilation of the zoning ordinance and map, and through the adoption of periodic zoning ordinances, they had been adopted by the town of Greenback.
What do we do then with the language that the municipal legislative body shall?
My position is, and I'll reference there's several ordinances in the record. Let me reference Ordinance 72, which is the 2007 zoning ordinance amendment. And that is Technical Record, Volume 3, page 357 is the specific map I'm referring to. When those intermittent zoning ordinances are adopted, it constitutes an amendment to the zoning map, which would qualify under 13.7.212. It is my understanding, Your Honor, that municipal entities do not periodically adopt a zoning map in whole. Rather, the comprehensive zoning ordinance and zoning map is intermittently adopted and then compiled into the published zoning ordinance and zoning map. And that, in my opinion, and you can take this for what it's worth, we're doing statutory interpretation here. There's no previous decisions of this court that assist us on this. In my opinion, that is what we're discussing in 13.7.212, because that is the way municipal and county governments operate, that they amend the zoning map, and the 2007 ordinance specifically amends the map and reflects M1 zoning on the Hutton property in dealing with a neighboring property. The amendment to the zoning map reflects the M1 zoning. That those intermittent amendments, as compiled and maintained by the official business of the municipality, that is what constitutes the presumption of correctness under 13.7.212. And to discuss 13.7.212 just briefly, that's the ordinance that we have relied on. Let me be clear, and I was clear with the trial court on this. The town has not been able to locate a copy of the original ordinance which applied M1 zoning on the Hutton property. There's no dispute about that, okay? That's not hiding the ball on that. The position that the town has taken and the position that we took below, and it's laid out in our brief as structured as we can make it, is the town, there is undisputed facts below demonstrated that there was a systemic loss of municipal records, and the town simply does not have all of its municipal records. But the town can and has proven through whether you call it parole evidence or extrinsic evidence, whatever words you want to use, evidence is perhaps the best word, that there was in fact an adoption of that M1 zoning on the Hutton property, as reflected in these historical zoning maps and as reflected in the currently effective zoning maps of the town of Greenback, and as reflected in the ordinances which we have provided both to the trial court and are referenced in our brief.
Is there an ordinance that's passed in which a map depicting the Hutton Farm area as M1 is passed by the board here?
Yes, Ordinance 72, passed in 2007. The specific page numbers where that ordinance is discussed are Technical Record Volume 3, pages 356 through 362, and Technical Record Volume 4, pages 410 through 420. The court can find this in the record itself. This is page 357. But on page 357, as part of the adopted zoning map, reflects M1 zoning on the Hutton tract. Now, this ordinance was to rezone a neighboring property. But the language of the ordinance says the zoning map of the ordinance, let me be more precise, the zoning map of the town of Greenback is amended to reflect the changes as shown in the ordinance. So to the extent there was an infirmity created by the absence of the original ordinance, our position is that it was cured by the passage of Ordinance 72 in 2007. And we have cited other relevant ordinances, but that's the best example.
Counsel, excuse me for interrupting. Sure. Could you address the impact and effect of the zoning ordinance 23.5?
Okay, so Ordinance 23.5 was passed after the town realized that there may be an absence of records. And it was passed in an attempt to ratify that absence. Let me be pretty clear on that ordinance as well, Your Honor. The court is aware, 13.7.203, it's 13.7.201 et sec, I think it's 203, requires that 15 days notice be provided prior to the public hearing on a zoning ordinance. There was 7 days notice for that ordinance. That's undisputed in the record below. The position that we have taken on our brief is that that ordinance constituted a police power ordinance rather than a zoning ordinance, and that it was a ratification of a prior enactment. That was the position we've taken in the trial court and the position we've taken on appeal. But the primary position we're taking is that Ordinance 23-5, whether valid or invalid, is unnecessary, because even absent the ratification steps taken in Ordinance 23-5, the town has made an adequate showing under 13.7.212 that the M1 zoning, as depicted in the compiled zoning ordinance and zoning map of the town of Greenback, is entitled to that presumption of correctness, and that the property owners did not meet their burden under the statute of showing by clear and convincing evidence that the published zoning map and zoning ordinance was inaccurate, which is, if 13.7.212 is triggered, it shifts the burden to the property owners to make that showing. Let me address, in the short time I have remaining, just a couple of points. Let me address the motion to dismiss the appeal that is pending just briefly. We've responded to that. Stand on my response, but let me point out a couple of things. Generally, in that motion, they have asserted that this appeal is moot. My response to that is, well, no, it's not, because a governmental entity has an ongoing statutory right to enforce its zoning ordinance. Even if Mr. Murphy and his companies have begun quarrying operations, if you begin a use and contrivance of the zoning ordinance, you obtain no vested rights or protection. That was at his own risk. He's chosen to begin and invest large amounts of money in the quarry. To the extent that it's found that he should have known from the beginning that this was prohibited by the zoning ordinance, that's a risk he stands to take. It doesn't mean the appeal is moot. Let me also state that the motion to dismiss disregards the relief the property owners sought. This was not simply a suit to enforce our ordinance. It was a suit for affirmative relief from the property owners, and mootness cannot be used as a sword by a plaintiff to defeat a defense that a defendant has brought. With that, I will address any other questions in rebuttal, unless the court has anything for me now. Thank you, Your Honors.
Thank you very much. Yes, sir.
Members of the court, Michael Kelly of the Knoxville and Blount County Bar, here with my law partner, Rob Quillen, representing the appellees, M&M Stone Farms and Tri-County Crushed Stone, who are owned by Mr. Murphy, Rodney Murphy, who's here today. Members of the court, the foundation upon which this case rests was laid over 175 years ago in a case involving the city of Knoxville. In Hume versus the mayor of the city, and the court, please, I love the old books. The court said from these authorities, and this was 1839, from these authorities, the necessary conclusion is that every proprietor of land, where not restrained by covenant or custom, has the entire dominion of the soil and the space above and below it to any extent he may choose to occupy it, and in this occupation he may use his land according to his own judgment, without being answerable for the consequences to an adjoining owner, unless by such occupation he either intentionally or for want of reasonable care and diligence inflicts upon him an injury. As recently as 2023, the Tennessee Supreme Court in the Pandhari Pandy case reiterated that, saying a property owner's right to own, use, and enjoy private property is a fundamental right. And to that end, the state legislature has passed ordinances beginning back in 1935 that say this is how a municipality or a county, what they must do in order to remove a property owner's rights to use his own property. And to that end, the courts have consistently said that if a city or county does not do that, then the zoning follow those procedures, all of which are laid out in Part 2 of Chapter 7 of Title 13 of the Code. Those procedures are all laid out, and repeatedly the courts have said if a city doesn't follow those procedures precisely, its action is void. And it is...
Counsel, let me ask you a question about what a city has to do with regard to a particular provision here. Under TCA 13.7.212, what does a legislative body have to do to authenticate a map?
Well, first, to go back, and I think just to emphasize, this is the first case that has ever interpreted Public Chapter 335, I believe, which was the amendment in 2009 that added this specific provision to the code, and it added it to Part 2. So the first thing I think a city has to do is, if you look at the phrase at the beginning, which reads, any municipality, quote, that has exercised zoning powers under this part shall, so forth. So the first part is, a city has to do those things. By that reference, it was clear that the legislature intended for a city to have to do those things reflected in Part 2 in order to even to come within the scope of this protection. Having done that, the city then has to compile its ordinance and map as amended, which is a point that council doesn't really address, but as amended so as to able to provide a member of the public with a current zoning ordinance and map. And then the next sentence is the important one. So they have to compile it, and then the municipal legislative body has to authenticate, compile, update, keep, maintain, and make available the zoning ordinance map and all amendments as a public record. And they did.
Add that sentence then, going back to my question. What do they have to do to authenticate it? And
They have to say, they have to have a public meeting where they say after 2009, this 2009 amendment, they have to say, we have to adopt an ordinance that says this, or it could be a resolution perhaps, that says, members of the public, this is our zoning ordinance and map as amended, so that a citizen can come in. And what's interesting in this situation, if you look back at these maps that keep being referred to, the trial judge listened to that evidence, and the trial judge commented that a citizen couldn't tell from looking at those maps what a property owner couldn't tell what his property would be.
Is there any procedure laid out in the statutory provisions in terms of how you authenticate it? And do we have any, are we going to open up the TCA and find this is how a municipal body?
No.
If that's the case, then the, 23.5, our 2023 attempt here, can that be authentication? And the 2023 map that gets passed or approved or ratified, and I know we've got the notice issue problem in that with regard to adoption of a change. Can that be authentication if the municipal body blesses it in 2023 and says, yep, that's our map. That's what
Are you referring to the 2023?
The 2023 ordinance that gets, we have the meeting that's called, the 6 days notice, we have the approval. Can that be authentication?
That's an interesting question. I don't think so, because that event only referred to specific properties. It didn't refer to the entire.
Okay, so it's got to be comprehensive.
And irrespective of that, I mean, what was clearly they were trying to do is they realized that town realized it had failed to ever do something to adopt an ordinance that zoned this property in one. How these notes, these little scribbles, if the court looks at these maps, the 2001 map they refer to that has the circle on it, it's a little handwritten note. The other maps that are with it, they're magic marker on a document. There's not anything in any of these that references an ordinance where it doesn't say even, here's the ordinance number 621, for example, where we zoned the property. There's not an ordinance. So to go back to that part 2 that the legislature requires a city to do, what should exist if a city in fact has adopted an ordinance? There should be an ordinance. They don't have an ordinance. There should be a copy. They don't have a copy. There should be minutes, as the trial court noted, where on 2 occasions the municipality would have adopted that. There had to be a publication of the public hearing. That doesn't exist. Because this is this particular government is mayor and board of aldermen, all of their ordinances to be effective have to be published or they're captioned. There's no evidence that this ordinance was published. They have not done one thing to validate, to show that there really was an ordinance, and this sort of speculation that, well, maybe this got destroyed when a new administration came in. Candidly, what difference does it make?
The publicly displayed map, do we know from the record how that was put together?
Absolutely, Your Honor, absolutely. And counsel, to his credit, he has done a great job, but he misstated the facts. I deposed the mayor, and I asked the mayor, who is here, I said, Mayor, that document that you've referred to so much, that you talked to Mr. Murphy about, that has this designation, how did that get created? And here's what he said. He said, I went down there personally to the courthouse with Mr. Campbell, and he put me in touch with the guy down the hall there, and they printed that off for me. And I said, the guy down, and he said, I can't remember his name. I said, Mr. Jenkins? No. This was before Mr. Jenkins was in that position. No, this guy was there in the property assessor's office. This isn't even planning. This is property assessor. And then I say, the assessor of Loudoun County, so you went to his office and it sent you to meet with somebody in that office? And he says, yes, in the back room there. And I say, so the map that was prepared was by someone, was done through the direction of someone in the property office. Did you look at any underlying documents that they used to prepare the map? And he said no. And I said, and do you know what they used to prepare it? He just printed one off there. So this is what we really have. We have a legislative body that doesn't have any of these necessary documents that are required, that has not authenticated the map as required by this provision, saying the mayor of the town can go down to the property assessor's office, say, print me something up. He can then put that on his wall without anything else. And then they can say to
the record whether that the mayor taking that step of going and talking to the person in the property assessor's office, is there anything that reflects that was at the direction of the board of aldermen?
No.
Or it's okay.
No. And so, Your Honor, here's what we're faced with. A citizen could come in that the town gets the presumption of that new provision in 2009, where based upon putting a document on the wall that was created by the property assessor's office and nothing was ever validated, that would make a mockery of all of the zoning laws that we have. So to go back, let me emphasize one other thing. There's frankly, too little time to get into everything, but I think the key thing here is for this court is how do we construe that 2009 change? And because it's never been construed by a court. And I think if you read through, if you look at they have not even commented in their brief on statutory construction. And they haven't, because if you use those most basic rules of statutory construction, it's clear what that meant. We have to assume that, as the courts have repeatedly said, the legislature intended every word to mean something, and that it knew the state of the law. It knew the Cherokee Country Club case. It knew where courts had strictly construed these statutes in favor of the property owner. And so it used the phrase, as I mentioned before, if the body has taken the steps necessary under this part, then they shall compile the list and authenticate it. And if they do that, then they are entitled to the presumption. And if they're entitled to the presumption, then if a citizen comes in and challenges it, as we have in this case, then that higher burden of proof is applicable. None of that happened here. So although the trial court took the position that we had proved by clear and convincing evidence that the town had failed to, that the zoning ordinance, what that they claimed was invalid, candidly, I don't think the trial court even had to reach that point, because they never had done those things necessary to have the benefit of the presumption. One other thing very briefly about the maps. Council, the one thing that is in their reply brief that is thing that is inaccurate is what they essentially say is, of course, after they put in these maps in their summary judgment motion, the record reflects that I took a deposition, 30B6, 30.026 deposition of the town recorder. And actually, I just asked for them to identify someone who could tell me about the creation, the authentication, the storage of the maps. And they produced the town recorder, who's appropriate because under the state statute, she is the person for a town that's employed by the town and has the duty to maintain all the public records. Now, they claim, and I asked her these questions, and she was candid. She didn't know anything about the creation of these documents. And I bring that up in my brief. Well, in their reply brief, they say, aha, you should have deposed Mr. Jenkins because he gave an affidavit. Well, there are two problems with that. The first one is even if you look at Mr. Jenkins' affidavit, you look at the affidavit that's attached, he does not say those things that are required for an affiant to authenticate a document. All he says is, I'm the custodian, and they're either business records or public records. Well, that's not enough. To authenticate a document, you have to comply with Rule of Evidence 803 and 901. A person can't simply say, oh, they're business records. That's what a court decides. So that's insufficient in and of itself. But more important, or equally important, and I'm about to run out of time, but there's a case I do want to bring the court's attention. I looked at that issue, and of course, under the, may I have 10 seconds?
Okay. Since you started, go ahead. Are you going to cite the case to us or what?
Excuse me?
Are you going to cite the case to us?
Yes.
Is that part of your, is that case in your briefs?
Yes. It's not in the brief.
Okay, then we got it.
So I've just asked the court to look at the Rule 30.026. It says that it's the obligation of the person, the entity providing the respondent to designate somebody who will testify to matters known or reasonably available to the organization, one or more persons. And this issue sort of came up in the, I'll just cite the case. This is the Metro Government versus BFI Waste Services, 212 10 App, Lexus 189. And this was a case which sort of indicated the obligation of an organization to provide a witness, not simply to be able to say, oh, you knew about so-and-so and you should have deposed him too.
And that case is cited in your brief?
I have not cited it.
Okay, you would need to send us the citation of the case and a copy of the case. Send it to the clerk for us, but do not argue the case, okay?
I will do so.
Thank you.
Members of the court, thank you for your time.
And a copy, of course, copy to the other side also. Okay. Thank you very much. Yes, sir.
Just a few.
follow-up points, and obviously I'm happy to address questions the court has with this time. Let me talk about the creation of the map. The map, which is page 13 of our appendix, simply to provide a color copy, but is in the record, was created by Loudoun County GIS, which there's an explanation for that in the record. And let me also say that that's not surprising because Loudoun County is the planning and zoning. They are delegated to handle planning and zoning functions for the town of Greenback. Loudoun County maintains a current effective compiled zoning map of the town of Greenback. I think that's an adequate explanation for the source of that map. Let me address a couple of points that I want to make sure I address.
Counsel,
Yes,
just
sure.
really quickly, can 23.5, the 2023 hearing,
Yeah.
can that constitute authentication in this case? I mean, it specifically addresses the property at issue. Does it need to be comprehensive to authenticate?
My opinion is no, it does not need to be comprehensive. Again, that's based on statutory interpretation. Let me say with respect to 23-5, it addressed all properties subject to the 1998 annexation, which I believe is something in the excess of 200 properties. That's in the record. It was a large portion of the town that was subject to the 1998 annexation. It constituted, in my opinion, and what I've presented in our brief, a police power ordinance that did not need to meet the requirements of 13.7.201 et sec, and therefore can constitute, again, in my opinion, a radical.
Only legislative, there's a number of ordinances that you're pointing us to, Ordinance 72, I believe. And is that the only one that specifically addresses the property that's at issue, not just as sort of a background part of the map, but it's touching upon in the legislature saying that's what we think this property is?
I believe that to be correct, that ordinances 72 and 23-5 are the only ordinances which specifically picture or reference the Hutton property. To the opposing counsel's point with respect to Chancellor McFarland's statement that how would someone know what their property was zoned, respectfully to the trial court, that was not really the issue here. This is not a case where someone came in and was blindsided by a municipal argument that the use they wanted to engage in was restricted. It was clear as day from the published zoning maps available in both Loudoun County and in the town of Greenback. Again, this is page 13 of our appendix and is in the record, what the zoning classification was for M1. Mr. Murphy, at a public meeting, it's on video, it's in the record, got up and said, I know this property is zoned M1. So this was certainly not a circumstance where there was any lack of clarity. I think there's some equitable and estoppel type considerations that we've raised in our brief that Mr. Murphy came to the problem. He knew what he was dealing with. Of course, he has great counsel who have raised these challenges to the sufficiency of the statute, but this certainly was not a circumstance where Mr. Murphy was blindsided, was not able to take this information into account. The property assessor's records, the town's records, the county records, all identified that this property was covered by M1 zone. Thank you very much. Unless the court has other questions, I appreciate your time.
I hear none. Thank you very much. I want to thank both sides for your presentation. Your case now has been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. Thank you both.
Thank you, Your Honor.
You may be excused.